Can I relocate my kids out of state during a divorce proceeding in Oklahoma? I'm Tulsa attorney James Wirth. That's the question that we have is, can I relocate my kids out of state while a divorce is going on? And the answer to that is generally going to be no, but there are some exceptions. So let me let you know how it all works together. Okay. So when a divorce petition is filed in the state of Oklahoma, it is served under Oklahoma law with a summons and an ATI, that's the automatic temporary injunction. And once that is served on the respondent, that automatic temporary injunction is an injunction that is in place under Oklahoma law. And it provides that everything needs to be done pursuant to the normal course of business, which means you cannot move the kids out of state. You can do vacations, I think it says up to maybe 2 weeks, but anything beyond that is going to be a violation of the automatic temporary injunction. Now, you can get around the automatic temporary injunction if there is an agreement by both parties. So if both parties agree, you can waive the automatic temporary injunction, and then that would not prevent you from moving the kids out of state. However, normally in these types of cases, you want to move forward pretty quickly to get temporary orders in place regarding custody, visitation, and child support. Once those temporary orders are in place, then the relocation statute is triggered. The relocation statute provides if a parent is entitled to, custody rights, visitation rights, the other parent cannot relocate the kids 75 or more miles away without first giving 60 days advance notice and opportunity to object to the other party. So if there's already an order in place related to custody and visitation, then you cannot relocate without first giving 60 days advanced written notice that must comply with the statute, which lists a number of things you got to tell them, that then gives the other party 30 days to file an objection, and then gives the court 30 days to have a hearing on that objection before the 60-day time period. Generally speaking, that's going to prevent a relocation while a divorce is pending. So what is the exception? When can you relocate when the divorce is pending? Generally, when that happens, it happens when that is an issue at the temporary order hearing. So if you've got a plan in place where you need to relocate, it's important for you, or typically important for the best interest of the children, then you would request a temporary order allowing you custody and to relocate the child, have a hearing on that, and the court would have to determine that's in the best interest of the child for that to occur while the divorce is pending. That's the proper way to do it, is you need prior court approval to do it as part of a temporary order. All right, so hopefully that answers your questions regarding the relocation, but if you're dealing with that circumstances, this general video is not going to be enough for you. You're going to need to talk to an attorney privately and confidentially about your specific circumstances to get legal advice. To schedule that with an attorney at my office, you can go online to makelawEasy.com.